Thank you. Good morning also from my side. Warm welcome to the second day of the workshop. We have a session now on substantive provisions, on accountability, amnesties, and use of assets, but also, of course, security guarantees. Carolyn Moser is based here at the Max Planck Institute. She is the leader of her own research group, Ensure, Rethinking European Security. And in order to save time, I leave it to that and hand over to Carolyn so that you can start your presentation. We look forward very much.
Thank you very much. So I will discuss security guarantees. Today, I will try and do it in 15 minutes so that there's enough time for Q&A. Actually, security guarantees is something that we did not really discuss a lot for quite a while, and that became, again, fashionable after Russia had launched its aggression against Ukraine. And for instance, when Finland and Sweden asked to be members of NATO, different EU members then extended some kind of security guarantees to them and said, as long as you are not part of NATO, we make sure that we would defend you in case. So those type of security guarantees are obviously key is Ukraine. So what I want to do is that I first want to flesh out what security guarantees mean in international law and international relations more broadly speaking. Where do they come from? What can they look like? What can they deliver and what can they not deliver? And then in a second step, discuss what is actually now the situation with Ukraine, which security guarantees are in place, which are not, and importantly, which are novel, because as we will see, the situation with Ukraine has made evolve, let's say, the regime of security guarantees. So let me first discuss in a broader way the law and politics of security guarantees. Now, security guarantees is an umbrella term, and it is used by different people, meaning very different things. It can go from a nuclear assistance or peace operations. And it is true that the concept actually has no definition, not in law and also not in policy documents or in political science. And so what it means is that it is very much in the eye of the beholder and dependent on the context, what is deemed a security guarantee, and importantly, what is deemed a sufficiently strong enough security guarantee. Now, interestingly, and I just want to briefly discuss this, in the past, security guarantees have been quite physical. What do I mean by this? We know this since ancient times in antiquity, for instance, emperors or empires would exchange hostages. So they would physically put somebody of their people, a cousin, a son, a daughter, to the court of the other emperor to make sure that actually if things go wrong, that person obviously will suffer. And so the idea was to actually not risk this person's life. We also had different types of security guarantees in the past. For instance, that you would sign a contract and say, if that contract is not being honored, then we swap territories, obviously including the population. How human rights compatible that would be today is a different story, but still the idea was that there were some tangible things that would be at risk if something went wrong. And now since World War II, we have a different type of security guarantee that is much more based on intangible things, and that's the promise of helping in case something goes wrong. So a third-party guarantee. So with this in our minds, I want to flesh out a bit what type of security guarantees there are and how we can maybe classify them. Because in legal terms, and I will come back to this shortly, there's a great variety of what they can look like. They can be more or less formal, they can be actually unilateral, they can also be multilateral, they can just be a declaration. And so what I have done is that I decided to categorize them according to a timeline, because depending on what the security guarantee covers, it actually is important pre-conflict, in conflict, or post-conflict. But obviously, post-conflict can already be the new in pre-conflict, but still I think it's useful to understand that there's not one type of security guarantee, but different types that cover different stages of a conflict or of a conflict cycle. And in general, several of them are there in parallel. So the kind of most reference security guarantee is a mutual defense clause. And that clause is most of the time contained in multilateral agreements, but also bilateral ones. Interestingly enough, actually, we have seen an increase of bilateral security guarantee agreements, even amongst EU member states recently. So that really seems to be a quite fashionable concept of writing down and then formally signing a treaty saying, in case you're being attacked, we will help you. Then there's also a different type, which is more of a pledge, where, for instance, members of a government will make an official declaration, sometimes to the press, but sometimes actually really as a unilateral act. And they would say, we would then defend country A in case something happens. And that's what I mentioned in the introduction. That's what a lot of European states did for Sweden and Finland. Then during a conflict, and that I think is new in the way that we see it, is that adopting sanctions is being seen as some kind of security guarantee regime, because what it does is that it is supposed to weaken the adversary, its economy, and so on and so forth. And so the idea is that you adopt sanctions that reach out and affect the enemy's economy and other parts of its apparatus, but at the same time, you also suffer a bit yourself. So that ties you somehow to the country that is under attack. Then still the in-conflict security guarantee is different type of supports. For instance, military, financial, it can also be humanitarian. So that when the country is attacked, you do not provide mutual defense, but you help the country defend itself by various means. There's obviously also peace operations, even though that is maybe misleading. So if it's still in conflict, it's probably more about stabilization. We have seen this in the past, especially under the UN umbrella, when there's a decision to send in stabilization forces to actually make sure that the belligerent parties will not go to war with each other anymore. And also post-conflict, that they survey a ceasefire or make sure that there's disarmament. And that's for me the final category on that time scale. That's disarmament. That's really at the end, when the conflict had ended. And that is seen as a security guarantee, because when there are no weapons, it's more difficult to go to war. Now, most of these security guarantees have a very strong legal component, because they rest on a UN Security Council resolution, on a treaty, and of different kinds of legal arrangements. Some of them are actually part of international law, others are administrative agreements. And from a legal perspective, all of them have an equal weight. However, from a political perspective, not at all. So it makes a difference whether you have a mutual assistance clause or actually whether you have, for instance, later on military support. So what that means is that there is a difference in how maybe lawyers would approach the topic from a purely formal point of view, and how, from a more political point of view, this is being seen and then also shaped. I think we also need to keep that in mind. And another interesting point is that most of these security guarantees are not justiciable and not enforceable. What I mean by this, so even if you have a treaty in which it says you will defend another country, well, there's no court that will oblige you to do this, and there's no police coming and saying, now you have to do it. And that is interesting, because it means a lot of it is legal, but it rests eventually very much on your trust that the other party will honor their commitment. And so it has also to do with, I would say, the quality of international law as such, and also how the international legal order looks like. We might come back to this in the Q&A. Now, let me look at what happens in the Ukraine context, because here we will see most of these security guarantees in place, or at least a quest for achieving them. And I will concentrate here in particular on European states and on the EU, because as I will show, they are now the biggest security guarantee providers. Also due to the United States, which is withdrawing its support progressively. Now, which security guarantees are in place? Support of different types, especially financial, humanitarian, and military. And while the US has downscaled its support, the EU is now the biggest financial donor, and actually it's not the member states, it is the EU through specific arrangements and loans. You might have heard about this. There's a package on the table to provide Ukraine in 2 consecutive years with 90 billion euros. And that is actually an EU-generated source of finances. Now, in terms of military support, it is the member states, sometimes using EU channels, sometimes not. And here you see a clear difference between Western member states and the Nordics, and countries being more to the south, where most of the support is actually being delivered by Western member states and by the Nordics. And the EU has also massively pledged to massively invest in Ukraine's reconstruction. Now, coming to sanctions, we are at the 19th sanction package right now. And the EU is aware that there's a lot of circumvention of these sanctions and has therefore tried new techniques. And what they exactly look like, you can read in a fascinating article by Katja Göcke in the latest issue of the Heidelberg Journal of International Law, where the EU is now taking a more extraterritorial interpretation of some of its sanctions, I would say. And as I said, here the EU has been quite strong. How effective those sanctions are is a different thing, but there have been a lot of sanctions adopted, so a layered approach to this. Then peace operations. The EU is currently deploying 2 types of peace operations, a military and a civilian one. And the military one is primarily about training, and I just checked before this talk, already 90,000 Ukrainian soldiers have been trained by that union mission, which is quite impressive, I have to say. And the idea here is that you enable Ukrainian soldiers to fight back home. So this is in place. And we also have the pledge of deploying a stabilization force once there's a ceasefire. This is a pledge made by the UK and France in January 2026. Let's see how this will turn out. And that brings me to what is not in place yet. And that is actually a clear mutual defense commitment somehow. So Ukraine is not part of NATO, it's not yet part of the EU, so it cannot rely on Article 5 of the NATO treaty, it cannot rely on Article 42.7 of the TU, which also foresees mutual defense. And so it is a quite uncomfortable situation for Ukraine, especially as it is still at war, because nobody wants to give the country these type of security guarantees right now. And for obvious reasons, we don't yet have disarmament and arms control as security guarantees. And now let me discuss what is actually new, because I find this quite interesting in legal but also political terms. So I said that member states, or EU states more largely, because the UK is also quite prominent here, they do not want to make a clear pledge for mutual defense. But what they have done is that they have signed security agreements with Ukraine, and they're all based on a template. Obviously, there are some variations, but these security agreements contain a clause where the country signing it pledges military assistance to Ukraine, which is, however, not mutual defense. And where there's a pledge saying, if you ever get attacked again by Russia, we would obviously supply you with all military material needed, and we would coordinate and help you and see what you need. So it's kind of a mutual defense clause minus, where you don't really get involved in combat, but where you try to make the other party or enable the other party to do the fighting on its own. What that is worth is a question that we can debate, but I find it very interesting that states have gone down this road. They have officially signed all of these agreements, and it looks very formal, but then they all have made statements saying it's only politically binding. Be it as it may, I think it's a new form of security guarantee, which is below mutual defense, but clearly above simply saying we will be there somehow in case you need us. There are actually quite some specific of how things would evolve. And finally, what is new, and I think really quite thought-provoking, is that the defense market of Ukraine is now being integrated in the European Union's defense market. A raft of legislative acts have been adopted to bolster defense production and joint procurement. And I will spare you with the details here and all the acronyms that you bureaucrats have found for these acts. But the important takeaway message here is that Ukraine is treated more or less as a EU member state in all of this. So it can get money from all of these things. And actually, it is even encouraged that EU money is being spent on increasing the defense industrial capabilities in Ukraine, which means of building factories there, of making sure that they are being equipped. And what I find fascinating about this is not only is that a clear security guarantee for Ukraine, but it actually makes EU member states also dependent on Ukraine, because it is now at the forefront of military technology. I mean, we know Ukrainians have been incredible in fighting this war and in developing new technologies and strategies, and which means that not only do European member states invest in Ukraine now, but they also invest in the technology they might need one day, and that will then be in Ukraine, I mean, physically. And this for me is actually quite interesting, and probably right now, and I will end here, that's, I think, right now the strongest security that has been given to Ukraine, because it creates a long-lasting imbrication, maybe even dependence. And I think that's always a good thing if you have partnerships, maybe friendships, where there's mutual dependence, because that will make it last longer and probably make it easier to activate in case you need it. And with this, I would close. Thank you very much.
Okay, great. So we continue in the room with the next two presentations on the panel. I will introduce speakers as we move to the presentations. So next is Dr. Iryna Bogdanova, who is now a researcher at the Schücking Institute in Kiel, and she is also the managing editor of the German Yearbook of International Law there. And before that, she held various positions in Luxembourg, also in Berlin at the Komikforschungsgruppe Klein, and before that at the University of Bern. So quite a wide-ranging number of stations. And she will now speak about frozen Russian assets and Ukraine's reparations. Thanks. We look forward to that.
So good morning, everyone. So all the wars end up with some sort of settlement. And yesterday in this room, we have been discussing what kind of flexibilities international law allows us when we talk about different peaceful treaties and formalities which have to be adhered to. So, but one of the issues which have to be resolved in one way or another in this context, obviously, the question of reparations. So this probably was the reason why this presentation was also included into the program. So I plan to structure my presentation along three main issues. First, I will briefly outline the cost of Ukraine's reconstruction as of now. Second, I will move to the discussion of the use of immobilized Russian central bank assets. In particular, I will focus on two issues: legal constraints and policy considerations. And lastly, I will briefly reflect on a few recent developments which has happened recently, which also gives us an idea of what is happening in that discussion. Because legally speaking, the discussion is has been frozen since 2022. And yesterday, when we had brief exchange with Ingrid, we also agreed that basically legal arguments are always the same. So you see enormous number of publications, but it's more or less the same discussion. So it will be interesting to see what happens. Maybe the new publication will solve all the issues. So I haven't read it yet because it's coming. So yeah. So to start with the cost of Ukraine's reconstruction, actually, when yesterday we were discussing free economic zones in those areas, I was thinking about this quote and thinking about how you plan to do free economic zones at places like this, but this is a completely different discussion. So getting to the question of cost of Ukraine's reconstruction. From the very early days of invasion, there have been various attempts and different initiatives in order to collect information about the cost of Ukraine's reconstruction and also to analyze these details. Here I refer to one of such initiatives. It's Ukraine Rapid Damage and Needs Assessment, which is conducted under the umbrella of the World Bank. But why I kind of refer to this information? Because it's kind of collaborative effort. Government of Ukraine, various ministries collaborate with different agencies of UN, which some of them based in Ukraine, some of them outside of Ukraine, and also with the help of World Bank Group. So, and obviously European Union services. So they have till now conducted 5 such reviews, and the most recent one was published at the end of the year 2025. So in particular, in their report, they always make distinction between 3 categories: damages, losses, and needs. When we are talking about damages, this is physical destruction. So when we talk about what do they mean by damage, it's that physical destruction about information about which was collected, analyzed, and kind of a figure was put in. So as of now, it's 195.1 billion US dollars. And it's the information for the 46 months course. So it's the information till the end of December 2025. So second category, which is much more broad, is losses. So it usually entails losses for the government and losses to the private sector. So, and it's obviously much higher, and you can see the information here. What is interesting for the purposes of just accounting is that damages are accounted as they stand for the duration of the 46 months. Losses have been estimated for duration of 46 months plus 18 months, meaning that even if the war will be over, for example, hypothetically by the end of December, there will be still continuous negative impact on business transactions and also revenues for the government. So it's kind of, and the last category is needs. So when they are talking about needs, they estimated how much money Ukraine will need for the duration, for the period of 10 years since the hostilities are over. So the needs are estimated. It's the cost of physical reconstruction based on the principle we rebuild but in a better way, and some sort of compensation for the losses incurred. What I find fascinating in this report, if you look at the first and second report, you see that the needs, it's cumulative sum of damage and losses. But if you look at the more recent reports, you see that they already distinguished because I haven't found very good explanation of why they start distinguishing, but probably because their sum of damage and loss becomes such a massive amount of money that they start kind of somehow also reducing it by saying that the needs are slightly lower than just by adding damage to loss. So I briefly put some sort of the most severely affected sectors of the Ukraine's economy here. And obviously it's housing, transport, energy, commerce, and industry. But also I thought it would be important to mention that significant losses have been incurred by such sectors as education and science, and also agriculture, which is an important sector for Ukrainian economy. So overall amount is now estimated to be 587.7 billion over the period 10 next years. And it's equivalent to 3 times Ukraine's gross domestic product. And then again, this was information up to the end of the last year. So now the hostilities are ongoing. So it means that we expect the figure to be even higher. And in general, if we look at the graph, I will quickly return that we saw that, for example, difference between the assessment number 4, assessment number 5 is that increase in the needs and damages was approximately 10-11%. So we can estimate that approximately 1 year of war adds up 10-11% on top of the existing amount. So next question is fairly straightforward, but I still had to address it. So if the basis of Ukraine's reparation claims. So according to the basic principle that the country that is responsible for wrongful act has to pay reparations is embedded in Article 31 of the draft Articles on State Responsibility, and it says that injury includes any damage, whether material or moral. On top of this, United Nations General Assembly in November 2022 had explicitly endorsed Ukrainian right to demand reparation for their Russian aggression. And I again put some sort of quote from this United Nations General Assembly resolution that including making reparation for the injury, including any damage caused by such acts. How has this been implemented in practice? As of now, based on this United Nations General Assembly resolution, register for the damage caused by the aggression of the Russian Federation against Ukraine has been established under Council of Europe. It was established in May 2023. It became operational in April 2024, and as of now, it functions more like a database where various claims are gathered. So basically, the first step of the reparation procedure is that they want to collect all the information about different damages, different categories of damages, and to have a database. This register is based in The Hague, Netherlands, and also there is an office in Kiev where they also try to collect this information. Now turning to next question. So we have seen how it looks like from Ukrainian side. We have seen the amount of damage that was caused, including some economic losses. We have seen that there is a clear international legal right, right for Ukraine to demand reparations and obligation for Russian state to pay its reparations. And at the same time, there's a parallel development. In the early days of the invasion, significant chunk of the Russian central bank assets have been immobilized. In fact, they have been frozen, but for political reasons, the term immobilized assets is used. So it's kind of more, because it's related to central bank assets, so it's more kind of considered to be more delicate to use term immobilized. So, and still then there have been always this kind of ongoing discussion to what extent we can use this money for the benefit of Ukraine, for example, military support, for macro financial support, or for reparations. So various estimates have been made. Approximately 300 billion USD have been immobilized till now. The significant chunk of this money is immobilized by the European Union member states. Also, there have been a certain amount of money was mobilized also by the United States, United Kingdom, Japan, and also Switzerland has around 9 billion francs of immobilized Russian central bank assets. So the overall kind of discussion how to use, whether to use, if it's legal to use immobilized Russian central bank assets, always revolves around two big areas of law. One of these is state immunity and entitlements of the central bank assets to certain types of protection. Second is law of state responsibility. So when we talk about central bank assets and state immunity, it's important to keep in mind that state immunity has two embodiments. It's immunity from adjudication and immunity from execution. When we're talking about the rationale behind the immunity from adjudication, we are talking about that the courts, one state cannot adjudicate the actions of the other state. When we're talking about immunity from execution, we are talking that measures of constraint cannot be attached to state property if there is no exceptions. For example, this property was used in commercial purposes, or this property, the state has given explicit consent to such usage. When it comes to central bank assets, there has been at least the minimum fair protection which is guaranteed to such assets is that central property of central bank or other monetary authority of the state cannot be put under any form of constraint as a result of a court judgment. And this part, as a result of a court judgment, in the discussion of use of Russian central bank assets plays a crucial role. Because the question is, does this immunity apply to the same extent to the acts of executive or legislature? In other ways, if, for example, Russian central bank assets, which are now immobilized, their use for the benefit of Ukraine is allowed as a result of executive or legislative action, will still trigger the same type of immunity protection as it is in the court judgment. And the current state of debate shows that there is a significant disagreement between the legal scholars on this issue. So one group of legal scholars support the idea that this kind of entitlement for central bank assets, they apply during court proceedings and also out of the court proceedings, in other way, to the executive or legislative actions. Another group of scholars disagrees with this view and argues that if we are talking about this entitlement, we are talking only about entitlement if we are talking about court proceedings. If there is no court proceedings, then there is no such entitlement. And central bank assets can be used for the benefit of Ukraine, etc. As an alternative solution, or as a way forward, which has been also widely discussed in literature, is the idea of what if we will frame some sort of narrowly defined exception on these rules in this particular case? Because obviously we do not want to frame very broad exception from such a very crucial issue as a central bank assets and their state guarantees. But what if we, in this particular case, we can find some sort of majority of states that can support the United Nations General Assembly resolution which will allow to use immobilized central bank assets just against the background of the overall conflict and those violations which has occurred. So this has also been discussed. Second area of law which has been implicated in this discussion is the law of state responsibility. In a way, if we can confiscate or use Russian immobilized assets, as a permissible or lawful countermeasure. And when we are talking about countermeasures, we are talking about measures which are illegal per se, but they can be allowed in certain cases. And draft articles on responsibility of states has certain prerequisites that has to be fulfilled when we're talking about permissible or lawful countermeasures. And there are three potential problematic requirements that countermeasures have to meet, which come into play in the discussion of the use of immobilized Russian central bank assets. One of this is the goal of countermeasures. Countermeasures are introduced in order to induce compliance. This is not punitive measures. So this kind of obstacle can be easily avoided if, for example, we say that immobilized Russian central bank assets can be used for the benefit of Ukraine, because we want to induce compliance of the Russian Federation with its duty to pay reparation. Or, as an alternative, we want to induce compliance with Russian Federation's obligation to stop illegal intervention into the territory of another state. Another two obstacles is that who can take countermeasures? And here we are ending up in a long-standing discussion in public international law about injured rights of injured and non-injured states to take countermeasures. And there have been, again, very diverse opinion among scholars. There have been scholars who argue that since the draft articles have been adopted in 2001, we have seen increase in the state practice of using countermeasures by so-called non-injured states, but at the same time, there is more conventional view that countermeasures are exclusively reserved only for states that are injured in the meaning of the draft articles. So again, very long-standing discussion without any unified view on the matter. And the last but not the least is that countermeasures as a rule have to be temporary and reversible in their nature. And this element is sometimes cited as a big obstacle for use of Russian central bank assets for Ukraine's reconstruction, particularly because of the element of reversibility. Even if temporality can be somehow met, the question of if we do something and things would transfer the ownership of the assets. So in a way, we deprive Russian central bank of its assets, of its ownership rights. Can we say that this measure, in a way, somehow meets the requirement of reversibility? In order to also conclude this discussion, I would like to refer to the legal memorandum, which was prepared by a group of legal scholars, including Felix Sands and Christian Thames and other colleagues on the 20th November 2023, in which they put the most plausible scenario of if immobilized Russian central bank assets are used, and if states that have used this method, these assets, want to justify them as a lawful countermeasures, what kind of arguments can they advance in order to justify this? The basic essence of that memorandum revolves around the idea that Russia violated obligations which are peremptory in nature, so peremptory obligations, and it gives rise to obligations erga omnes. And based on this ground, other states, not only Ukraine, can take so-called collective countermeasures. So this is with regard to the question of the standard who can take these types of measures. With regard to the goal, what kind of compliance goal do these measures pursue? They were talking about two goals. First, it's stop illegal invasion of Ukraine and aggression, Russian aggression, and at the same time also to induce Russia to pay reparations. With regard to temporality and reversibility, they were talking about that, well, these requirements not as strict as they sometimes interpreted, so they should be fulfilled to the extent possible, but at the same time, they should not constitute a significant obstacle. And then, in a way, the argument is that after Russia pays its reparations, it can return to the overall kind of community of states, and that it still will be entitled to state immunity guarantees, which were given to it before its invasion of Ukraine. Now turning to more policy considerations, because in the context of this discussion of the possible or impossible use of Russian central bank assets to compensate Ukraine, there have been a lot of policy arguments made, and they have been as strong as legal arguments at the same time. So one of the most strongest arguments in favor of such a move is that there has to be some sort of accountability for Russian actions in Ukraine. And second, which is more pragmatic step, is that cost of reconstruction. We have seen how significant cost of reconstruction will be in the course of the next 10 years. So the question that hangs in the air is who will foot the bill? Anyway, if we do not use these assets, then where will we take this significant amount of money to compensate Ukraine? Policy arguments against, which are very often surface in this discussion, is the role of the euro, to a less extent dollar, as a reserve currency. There have been a significant reservation, which has been expressed also by the European Central Bank, about that any such policy, any such move might have significant strategic considerations for the stability of euro as a reserve currency and for the position of euro as a currency in general. And second argument is taking the precedent. So there have been a lot of concerns that if we allow this in this case, then any other time when any country will engage in military confrontation with other countries or potentially will join the forces as as a NATO member, then there will be a possibility that the central bank assets of this country will be blocked and used in some other jurisdiction. In response to this policy argument, there have been counter arguments which have been developed. So, in particular, with regard to the question of reserve currency status, people who oppose this argument say that we haven't observed any significant currency flight happening since the Russian central bank assets have been immortalized in 2022. And second, which is also a related argument, is that as of now, there is only a limited number of reserve currencies which are attractive enough for states to keep their reserves in these currencies. And this, in a way, limits the possibility of the states to change and move to another currencies beyond euro, USD, and several others. And a counter argument to this idea of that we would settle a dangerous precedent is that we can talk about very narrowly defined exception, which applies in situations of a blatant violation of the cornerstone principles of international law, such as the Russia-Ukraine war. Now I will briefly talk about several recent developments which have been happening in practice, because this discussion, they have been there from the early days of the invasion. So if we look at this discussion of use of immobilized Russian central bank assets have been immobilized on the fourth day of war. So on the 28th of February 2022, countries under the Aust, under the umbrella of G7, decided to immobilize these assets, and since then they have stayed immobilized. And legal discussions, they are more or less revolved around this idea of a law of state immunity, and countermeasures is a possible justification, and different arguments but exceptions. In the recent past, several interesting things have happened in practice. First of all, G7 adopted a special agreement on the use of extraordinary revenues which have been generated by this immobilized Russian central bank assets. So Ukraine was in need of macro-financial support, and G7 in Summit 2024 agreed that they will issue so-called extraordinary revenue acceleration loans to Ukraine. So Ukraine and individual member states of the G7, they signed special agreements based on which loans were provided to Ukraine. But the repayment of these loans will be done by the use of extraordinary revenues which have been generated from the immobilized Russia's sovereign funds. Second interesting development is that initially, Russia's central bank assets in the European Union, they have been frozen under the sanctions framework. So they had to be reviewed every half a year, which gave a lot of political leverage to countries like Hungary to oppose renewal of these sanctions and to threaten potentially to unfreeze these assets. In December last year, European Union decided in favor of permanent mobilization of Russian central bank assets. And based on Article 122 of the Treaty on Functioning of the European Union, there have been adopted the decision, Council resolution, which allows permanent immobilization of Russian central bank assets. And in late February this year, Russian central bank actually announced that it has brought a complaint before the Court of Justice of the European Union in Luxembourg to challenge this permanent immobilization based on several grounds based on several grounds in the European Union law. So as of now, we do not know what the court decision will be. There are significant reasons to think that the court might decide to agree that it has a jurisdiction to alter the matter. Whether it will agree with the arguments submitted by the Russian central bank is still debatable, even among EU scholars. And last but not the least, in December last year, 35 countries and the European Union signed a new convention to establish an international claims commission for Ukraine. So this is so-called second step of the reparation process. So before we had only register of damage, which was established as a database which collects and analyzes information on the damage caused to Ukraine. This is the second step, convention to establish international claims commission, which will already look into the substance of the claims which is submitted to the register of damage. And the third step, as it is envisioned now, is will be some sort of reparation fund. But again, there is no decision what will be the sources from which this reparation fund will be financed. I think with this, I will conclude, and I'm looking forward to the discussion.
I introduce Dr. Gleb Bogush. He is currently a researcher at the University of Cologne, where he is working with a grant by the Philip Schwarz Initiative of the Alexander von Humboldt Foundation. Previously, he was an associate professor of international law at the Faculty of Law of the Higher School of Economics University in Moscow until 2022. And then in 2022, he left and then first worked as postdoctoral scholar at the University of Copenhagen before now moving to Cologne. We look forward very much to your presentation on accountability.
Thank you. Good morning, everyone. I think it's not initially planned this way, but I think it's quite symbolic that we the final talk of today is dedicated to the issues of accountability and peace in Ukraine. And I think this topic was discussed already yesterday, from the very beginning, from the keynote, and then a lot of speakers refer to issues related to accountability. I will build my talk around three major points. The first, I try to explain why accountability matters and why it's important to address it properly, and what is the current stakes on this issue. And then I try to answer the question: what can we do now, given the current stage of the process and all these initiatives that we discussing, and also concerning potential peace treaty. And then I conclude by, I think, some utopian thoughts how it should be done and what can be addressed if we really need, if we really want to achieve genuine, sustainable, and just peace. I think this is an idea that we all share. That's the plan for this talk. So first, why it matters. I think it matters. I think for every conflict, for every peace project, and every major conflict is, of course, includes violations of human rights, international crimes, and other grave breaches of international law. And that's why we need to address them, first of all, by accountability measures. But this conflict, I think, is unique because the impunity, the lack of accountability, I think, lies in the heart of the conflict. And it's one of these, maybe not root causes, as very often referred by various parties, including Russia, by the way, always speaks through its speakers about root causes of the conflict. But I think really impunity that perpetuates through various stages of various reincarnations, I would say, of the Russian state policy and regime, as also Soviet Union, is this chronicle impunity is, of course, empowers future violations. And current war is not just manifestly illegal. I think it's common denominator between us, but it's also, I think, roots in this impunity. I will talk today mostly about criminal responsibility, about individual criminal responsibility, because I think it's a crucial missing element of the current situation. And although it's widely discussed, there's a lot of initiatives, we still don't have proper process. And in the history, we could see that there was no proper precedent when the representatives of Russian state have been called to account, either by international justice or by domestic justice. So this is, I think, one of the most important elements. And in this regard, it's important to understand that it's not just post-conflict ideas. We are not just discussing the future settlement and the future accountability architecture. We also need to understand how we react, how the accountability address existing processes on international level, and also what parties to the conflict are doing right now. And here we have the very, I think, challenging time. So zeitgeist is not in favor. It's not in the favor of accountability. In the recent times, it's not just the United States that make clear turn from ideas of justice for international crimes. On the insistence of United States, the relevant paragraphs have been disappeared from the international resolutions, particularly in General Assembly and Security Council. And if you compare the text of the resolutions of the General Assembly, so I recall resolution of adopted from the first anniversary of the invasion. This was a resolution that gained support of 141 member states of the United Nations. And this resolution demands proper international investigation and prosecution of the crimes committed on the territory of Ukraine to achieve the just and sustainable peace. And the recent resolution doesn't even mention the accountability. The peace treaties, which I think are very relevant because they are not just new and recent, but they are brokered by the same mediator, President Trump, his administration. I mean, the Armenia-Azerbaijan peace treaty shows that accountability as such is not mentioned as the relevant condition for the peace. It just provides for the withdrawing of the claims before international tribunals, and demands. I think this is also fair for Ukraine situation. Release of the prisoners, and that's actually the tone that this treaty contains. And here we have, of course, quite challenging a time when the accountability is certainly not placed at the center of the discussion around these initiatives. Currently, we have several, I think, tracks of accountability for international crimes, and also non-criminal responsibility, particularly the measure of state responsibility. One of the concerning reparations, Iryna just discussed this issue, and that presents the really challenge for accountability in this area. So the first, the international track. Currently, we have the investigations before by the International Criminal Court. This court investigates the allegations of three categories of international crimes, mainly genocide, crimes against humanity, and war crimes committed on the territory of Ukraine. We have 6 public publicly announced arrest warrants, and two of them concerned practice of deportations of civilians, in particular Ukrainian children, and four of them are dealing with the attacks on civilian infrastructure and indiscriminate attacks on the territory of Ukraine. All these warrants are not executed, and the prospects of the executions are quite uncertain because they concern the highest commanders of the Russian army and Vladimir Putin personally. There have been two instances of Putin visiting the member states of the states parties to the Rome Statute, and the Mongolia and Tajikistan, and even the state parties to the court didn't agree to condemn officially those two state parties. International Criminal Court can be stopped in this investigation only, as was mentioned yesterday, just by resolution of Security Council. So this track is independent from any potential challenge by the peace treaty or any other process. But Security Council may freeze investigation for 1 year, according to the statute of the court. Also, the special tribunal for the crime of aggression that was created by the Council of Europe, and now it's a process of the settlement of this tribunal, of the creation of the management agreement of this tribunal. And currently, there are two elements of this tribunal which I think raise concern about its potential. First is, of course, the immunity of so-called Troika, which is particularly important for the crime of aggression, since aggression is a leadership crime, and it's still quite, I think, uncertain what would be potential suspects before this tribunal, since the key leaders are protected by immunity and leave until they leave the office. So in the context of regimes that exist in Russia, in Belarus, in North Korea also, it means basically that they have kind of lifelong immunity provided by the International Tribunal. This is, I think, quite concerning. It's technically made by attaching the tribunal to the territorial jurisdiction of Ukraine. It also explained the fact that I think it's the second concern I personally have, is that the prosecutor of this tribunal will not have proper motu power, so it will be dependent on Ukrainian prosecution office. So basically, Ukrainian executive branch, and that means that, of course, there would be a lot of potential allegation against impartiality of that tribunal. But I think it's very important accountability track, and this is, I think, the key element addressing the crime of aggression. So I think this is something that we always have to be in mind if we want to achieve meaningful justice in the case of Ukraine, because the crime of aggression is actually lies in the center of this of the evil. It's exactly the case in this aspect. It doesn't happen in every conflict, not even in all international conflicts, but in this conflict, most of the damage, most of the lives that have been lost, the only international crime that is potentially could be described as civil is, of course, a crime of aggression. What is achieved, I think, is mostly on the side of Ukraine and its partners, is, of course, documentation and witness and evidence gathering. we have significant results achieved by, first of all, Ukrainian prosecution service and civil society in Ukraine. And the numbers of the cases that Ukraine is prosecuting. Ambassador Korinevich, Dr. Korinevich, is also a legal scholar, very well known, mentioned yesterday 200,000 war crimes. I think he referred to the open cases, the investigations, active investigations opened by Ukraine. Of course, we can discuss these figures, and to me, they seem a bit exaggerated. But I think anyway, the scope of this crimes is staggering, and this is very important that civil society is actively taking part. And this also we also have cooperation on international level. The Joint Investigation Group created under auspices of Eurojust and International Center for the Prosecution of Aggression, which would be quite instrumental in case I hope that special tribunal will be created. I think it would be quite important to be aligned. So the concerns that have been voiced yesterday that the Ukrainian efforts are so far, at least in practice, are only directed, and this is quite understandable, on the crimes committed by Russian forces, and also I think, at least two legal developments that also voiced with concern, that also raises concerns, is the reservation made during the ratification of the Rome Statute, referring to Article 124, and also the limitations that Ukrainian legislation also has in cooperation law with the ICC. So they currently, at least it is a part of the current Code of Criminal Procedure of Ukraine that limits cooperation with the court only by crimes committed against Ukraine. This is, I think, makes the case of commitment to prosecution of its own crimes. But we see that on the side of Ukraine, it's at least genuine efforts to and commitment to justice, and I think this is quite clear. I think what has not been mentioned also yesterday, that Russia has also participated in this, I would say, also plays this accountability arguments. Although there is no case that is known that Russia prosecutes the violations committed by its own soldiers, its own members. Just a few cases which have been brought before Russian courts, they all concerned events committed on the territory of Russia proper during the occupation by Kursk, part of Kursk Oblast, by Ukrainian army, and they all have been qualified as domestic crimes. So this is typical, I would say, pattern of ignoring. There was actually the case that under international law could be qualified as looting what they have been prosecuted, and also they include murder of the family. But at the same time, they have been prosecuted under domestic law. That shows that this is only accepted as fully domestic matter, not so Russians don't commit war crimes. So this is unfortunately the position. But what started to happen, at least since 23, is that Russian courts, also courts created on the occupied territories of Ukraine, started to prosecute Ukrainians, mostly military, for war crimes also. So they started by prosecuting, trying prisoners of war for domestic crimes in violation of the international humanitarian law, and now it's a lot of prosecution of war crimes. So this any peace negotiation and settlement on accountability should also deal with this fact. So in any discussion, there would be argument that, well, we have also war crimes that have been prosecuted by the courts that took genuine, because they are not just occupation courts, but they also Russian courts created on the territory of Russia. So that's also something that I think important to this debate. So this is the I think the landscape. So we have existing practices. We have very, very modest results so far when it comes to the prosecution. We don't have many convictions, especially real convictions. So the most of trials that Ukraine as they are conducted in absentia, and we have just one complete case on the basis of universal jurisdiction. It's a case in Finland when the Russian, one of the leaders of Russian neo-Nazi group, who have been convicted to life imprisonment for crimes committed in 2014. So it's an old story, but it relates to the events in Donbass, and this was the potential case, by the way, for the ICC, because this case fits into jurisdictional framework of the International Criminal Court. But Finland was the only state that completed the case, and there have been several investigations, active investigations on the specific cases, but the most investigations, of course, are not concerning specific allegations against individuals. They are so-called structural investigations. So this is what I think the potential peace agreement should address. So far, we have several initiatives, and we had a long history of negotiations already. And mostly, what was mostly debated is, I think, to just so-called negative accountability, or the provisions and initiatives concerning the amnesty and withdrawal of claims. So this is a typical initiatives, mostly produced by Russia or Russian negotiators. So I think it's clear that the one of the provisions of the so-called Trump peace plan 2028 was the fruit of discussion between Steven Witkoff and Kirill Dmitriev. Was the most recent reincarnation of this treaty. So this plan contained this idea of amnesty. I think there is a clear rejection on the side of Ukraine of the blanket amnesty. I don't want to go into detail about the legal implications. I agree that blanket amnesty for international crimes is not compatible with international law, although it's of course open to debate whether this constitutes jus cogens, the peremptory rule of international law. Probably not, but nevertheless it undermines by definition the peremptory norm, namely prohibition of international crimes, including the crime of aggression, the crimes against humanity, and the war crimes. And there is a credible allegations that systemic impunity for these crimes in this war. And moreover, this is not just sporadic episodes. It's a clear state policy of the Russian Federation that should be addressed also by criminal trials. Currently, I think it's not realistic to expect that any substantive provision on accountability, whether it concerns the scope of amnesty or whether it concerns support of international efforts, or whether it concerns accountability architecture on the national level, or any type of commission, joint commission, truth commission, or commission of investigation, is realistic in the current disagreement. So I support the view that probably on the current situation, the best possible result, the best the best potential solution is just to make a general statement on international law that all the process should be conducted in accordance with international law, and defer the issue of specific accountability mechanisms probably to the future separate exam. And here I want to say that a crucial element of any accountability solution would be, of course, the will to do it on behalf of Russia. As mentioned before, we have very asymmetrical conflict, at least when it comes to violations. We have definitely violations on the Ukrainian side, but they are uncomparable in scope and scale. And without inclusion of the Russian system of justice, whether it could be created is a different question. No proper accountability would be possible. So basically, without changes in Russia, there would be no sustainable peace. And without accountability, without the precedent of making state accountable for violation of human rights, would be not possible to achieve changes, genuine changes in behavior of Russia. And this is, I think, on the interest of everyone. It's the interest of Europe, it's the interest of Ukraine, it's of course in the interest of Russia. So just maybe 2 minutes on what I see as kind of utopian view on this issue. So I recall the welcoming words Professor Peters, who referred in her turn to Antonio Cassese. And although it's still famous to think about his ideas and his vision as utopian, as realizing utopia, but I think it was most realistic utopia. His own achievements, I think, as not just a scholar, but as a justice actor, is a clear example of what can be achieved. Of course, when the moment comes. So I'm really happy to listen to one of his last lectures, where he in the Hague Academy, when he really spoke about this. And I think this is not just the utopia, but it's just we have to be prepared for and to have a realistic plan for that really could bring us closer to the genuine peace. Here we have several, I think, very important points. The first is, of course, that we need to create real incentives and demands, that based on also not just on, I would say, threats or the negative consequences for Russia, but also based on incentives. Ukrainian society is definitely for justice. The demands of justice is very strong. We don't know about Russian society a lot. We just know that it's really should really take into account the interest of Russia's state and interest of Russia's society in achieving truth and justice. And I think the truth process is of key importance. We have now, unfortunately, very different, I would say, fragmented information space between the countries in a conflict. This is true for every war, especially for the conflict like that. And this is why I think we need the missing element in our talk is, of course, the Truth Commission, the commission that could be able, probably on bilateral basis, without imposing truth on each society to deal with the events starting from the very inception of this conflict. And of course, this includes also the need to have a clear goal of achieving accountability. The individual responsibility, I think, is a key, but we also have to see other methods. So the compromise solutions are possible, but they should not undermine the main goal. And that's I think the key for the future peace. And I really hope that this day will come. Of course, I don't know when and how it would happen, but what we could do, I think, is to be ready for that. To have a realistic, but also principled plan. And we have to clearly demand from the violators of international law what we can demand from them, and what is the interest of all involving parties to accept this. So that's all, and I sorry for taking a little bit more minutes than I